May it please your lordship. May it please your lordship. Concern with the other side, lordship, I beg to mention item number 15, lordship. For upgrade, lordship, taken at 2 p.m., lordship.
Pardon me?
Lordship. Item number 15, my lord.
You want an adjournment?
No, lordship. Upgrade
Upgradation.
at 2 p.m., lordship.
Okay.
I have already informed the other side, lordship.
What is the matter about? What is the subject matter?
Matter lordship relates to revenue. Revenue dismiss the matter. Land, visiting that land,
Board of Revenue matter.
lordship.
Okay.
Would like to.
Maybe concern of the other side, item number 12, maybe adjourned for today. Item number 12, with concern of the other side, I beg to adjourn the matter.
Oh, no. On Tuesdays and Thursdays, you'll have to give us an advance notice.
Actually,
Otherwise, you're not adjourning any matter.
Mr. Mondal, last night, Mr.
No,
Mondal
whatever
had some
be,
health
we're
issues.
not
my lord,
adjourning
so-
any matter. Once advance slip is not given on Tuesdays and Thursdays, you're not adjourning.
Okay.
Supplementary list, item 16 for admission.
May I please, your lordship? Lordship, please say. Contested matter, your lordship. Contested case, your lordship. The petitioner is in cooperation detention camp, your lordship, for which a separate eye has been preferred, your lordship.
The petition is in detention.
Detention, your lordship.
Okay. What is the best document you have to connect you to your projected parents?
Yes, your lordship. At page number 110 is the impugned judgment or opinion, your lordship.
Yes, yes.
Is that a petition, your lordship?
What's the best document you have to connect you to your projected parents?
Lordship,
Don't close the voters list.
Here, your lordship, I have relied on some grandparents' documents, your lordship, along with, because the father did not cast vote at the year of 1965 or 1971, your
Close
lordship.
the voters list. Except for voters list, what document you have?
Yes, lordship. Lordship, if lordship kindly see exhibit 1, your lordship.
Exhibit
1, your lordship.
page
Yes, lordship. Exhibit 1 is 30 and 31, your lordship.
51.
31, your lordship. Yes, vernacular typing copy is at 49, your lordship. Sorry, your lordship. 49. Vernacular portion is 50, your lordship. And your lordship,
But this document does not appear to help you.
lordship.
This is exhibit A. Correct? Jamabandi.
Yes, your lordship.
But have you read the deposition of DW3, the Mandal?
Yes, your lordship. Here, your lordship, the DW3, your lordship, deposed that this would not match, your lordship, not tallied, your lordship, with the official documents, your lordship. So, your lordship, the summon, your lordship, served to the person, actually, the new pata has been allotted, your lordship, in place of
The
this, your
difficulty
lordship.
is, you see, the difficulty, if I say, you'll be aggrieved. But the difficulty is that the council does not know how to deal with a land document. He has
Lordship,
no idea to
lordship,
deal with the land document.
lordship, true, your lordship.
Mr. Sharma,
Okay.
although the evidence is failing, but it's an opinion of 2024, August 2024.
Yeah.
We give her a bail
Lordship.
in the meantime with directions because she's been taken into custody.
23 May,
Yeah.
Your Lordship.
We'll examine the documents. They
Lord.
It's very sad that the council do not know how to
Hmm.
deal with the land documents. Actually, they do not know.
Your Lordship. This have been the earlier the one पता नहीं.
You're saying yes, will not do because you'll have to point out what is the mistake done. Are you aware of it?
Lordship, someone served in the earlier document.
No, then you're also not prepared.
And Your Lordship,
Okay, since you're challenged within a year, we give you bail. Uh, Petitioner also heard, one of them is Mr. Adhikari, Mr. Islam, Mr. Sharma. Spera. By filing this petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has a sealed page 110, opinion dated 21/8/2024. Last name so and so, so and so. Thereby declaring her to be a illegal migrant of post 25 1971 stream. Next. By order dated 16/7/2025, while issuing notice, the records of the tribunal was called for, which is received. Next, accordingly, the learned counsel for the petitioner has prayed for interim bail by submitting that on 23/5/2025, the petitioner has been taken into custody and she is presently at
Your Lordship, at Kokrajhar, Your Lordship. Your Lordship.
Kokrajhar.
Lordship.
She is
See that, Lordship.
it's submitted that at present the petitioner is at the holding area 7th
Seventh
AP
Assam Police
Battalion, Saraikela, Kokrajhar. Next, the learned counsel for the petitioner has prayed for bail, which is opposed by the learned standing counsel for the FT matters on the ground that the petitioner has failed to establish her link with her projected parents and grandparents and therefore, there being no infirmity in the impugn opinion, bail may not be granted to the petitioner who is a declared foreign national. Next paragraph, be that as it may, considering that the notice has been issued to the challenge against the impugn opinion dated 21/8/2024, the court is of the considered opinion that the petitioner be released on bail on the following conditions. The three conditions are there. The family members shall the family members shall give bail of rupees 5,000 with two surety of like amount to the satisfaction of the Superintendent of Police Border, Golaghat. As there are three conditions, add one more. There that the as a condition of bail, the petitioner shall appear before the border branch of this will be which police station? Police verification is at Golaghat, Bokaghat. Yes, Bokaghat police station. Once a month till further orders. Next paragraph. As the records are received, the court is inclined to issue rule returnable forthwith without requiring any fresh steps to be taken. This is the matter for hearing in the month of November 2025.
Highly obliged, Lordship.
This order will be a common order in police cases, I also. And you say that the interrogatory application is disposed of. This order will be in common order. IA will be disposed of. The last part is there. The IA will be disposed of. In terms of this order. List thereafter that list in the month of November 2025 for hearing.
Highly obliged, Lordship.
Item 17,
I'm happy with it. As per the order dated 6/9/2024, Miller, and pursuant to the expiry order, Miller, petitioner arrested on 25/5/2025. At present, he is in detention camp at Gwalpara. In IA, Miller, expiry order is page 9. Tengah kat. Dia belum.
有多那个是蛮的。
Yes, madam. Yes, only file written statement.
Then you did not give evidence.
And my lord, uh,
You got the records, Mr. Payne? We had requested you to get the
Yes, yes, my
records.
lord, we have not received, my lord. Yes.
Hmm. Just check this order.
Next week, your lordship may fix any date, we will get the report.
No, just take note of this order. You'll have to note and send it. You'll have to note and send this downloaded order.
I mean, communication made lordship, next week, it will come. Lord.
Okay. Fix it on Wednesday.
yes,
Okay. Both all sides are represented. Mr. J. Payne, Leonard Stanikos for the FT matters has submitted that pursuant to order dated 37/2025, a requisition has been issued for the record. He prays for some time to produce the record. Next, as paid for, list on 27/8/2025.
published.
This will be the writ petition.
Item 18.
No separate order is passed in the interrogatory application.
Yes, please, Your Lordship. Here in this case, the petitioner was taken into custody in terms of the opinion
Record size.
dated 27/3/2025.
Record size,
Presently, he is
Record आना है. To wait for some time to LCSB. It's not come. It has been communicated, but it is not come.
So he trusted his vote along with his father, and the inquiry report also says that he has not migrated.
No, we understand, but still the records we have to examine. Yeah. Same 27th. Just say the both sides also all sides are represented. It is seen that despite requisition for records, it is seen from the office note dated 11/8/2025 that despite communication of the requisition to the learned member, foreigners tribunal 7th Tejpur by email and by speed post, the relevant records have not been received by the registry. Next para. The registry shall send a fresh reminder for urgently sending the records.
May I pay for a order because I have been informed that he is suffering from some ailment.
আহিব নহয় ৰেকৰ্ডটো দুদিন বন্ধ আছে 28-29 বন্ধ 25 তাৰিখ বন্ধ হা Next, by the learned member, foreigners tribunal 7th Tejpur is requested to expeditiously send the records so as to reach the court by 28/8/2025. Next, list on 29/8/2025. before the next date, you say let this order be brought to the notice of the AOJ FT section.
All right.
Item 19 for orders.
Nineteen and 20, my lord, they have submitted the written argument in this case, in both these cases, my lord. I was supposed to report on that, my lord.
Pardon me?
No, 19 and 20,
Yes.
they have submitted written argument. I was supposed to report that, my lord, argument. I have prepared a small written argument. Before that, my lord, I like to, because
Take it up after some time. Let the council be here.
Yeah.
Take it after some time.
their argument has been submitted.
Okay. Where is it?
Yes,
Written
their arguments are there.
Item 1920.
Yes, argument. Only my part is.
Why do? Huh? Yes, sir. तो याद लगा दिया ना ऑर्डर शिफ्ट लगा ऑर्डर शिफ्ट लगा Okay, so you have prepared a note, you will give it.
Yes.
Okay.
Just I will look to point out two things, my lord. Your
Yes.
lordship. These cases, both these cases, my lord, the matters are identical. The facts
Yes.
are there already given. But I
Yes.
have reported, my lord, I'd like to give some factual aspect. Both these cases, my lord, they were declared for that.
Yes.
Admittedly, they are declared for that. They approached the honorable court. This honorable court dismissed. They filed review. That also dismissed. They approached to honorable apex court. They are also in item number 19. And item number 20, my lord, it is, they approached this honorable court. Review was dismissed. Review is also dismissed. Then, my lord, they did not approach probably the apex court. Then they were picked up. They were handed over to BSF, my lord. BSF sent them back. They again came back. And they are now, my lord, after handing them over by the BSF to us, we are keeping them in the holding center at Tripura. This is the factual aspect. So there is no dispute on that. Now, only question, my lord, they are saying with regard to the deportation. My lord, with regard to deportation, I would like to rely, my lord, your lordship may kindly see the Tribunal 1. That aspect we have to maybe see. 2005 5 SCC 665. Only 2-3 further I would like to rely, my lord. Because this aspect, my lord, we have not discussed prior to this. That's why I like to point this out. 2-3 paragraphs of this Tribunal 1. 2005 5 SCC 665. Para 74, from para 74 onwards, madam. One aspect we have to remember, my lord. These are the cases. The Foreigners Tribunal of Assam. Paragraph number 74. Yes. May I? Sir. My lord, before going to this, my lord, you lordship may factual aspect, we have to remember. My lord, those persons under the foreigners tribunal in Assam, the persons who are determined whether he's a foreigner or not, it's under 6A of the Citizenship Act. Under the 6A of the Citizenship Act, only those persons who are covered by 6A of the Citizenship Act, they are in, my lord, they are in determination whether they are foreigners or not. Because, and 6A specifically says, my lord, only those persons who has migrated from East Pakistan, the specific territory, in that case, 6A will apply. So other cases, other than the 6A category, my lord, the foreigners tribunal is not going to take any decision. So whoever is, my lord, against whom there is a determination in foreigners tribunal, all those are covered by 6A. And those are specific from a specified territory. And that is, my lord, the specified territory means the, my lord, erstwhile is Pakistan, that present Bangladesh. So that is known to everyone. But that fact we have to know. That is known to everyone. There is no dispute on that. Now, my lord, and my lord, your lordship, let me say para 74. I would like to read slowly I'll read, my lord. We consider it necessary here to briefly notice the law regarding deportation of aliens, as there appears to be some misconception about it, and it has been argued with some vehemency that aliens alone also possess several rights, and the procedure for their identification and deportation should be detailed and elaborate in order to ensure fairness to them, of them. Then, my lord, there 75. In Introduction to International Law by so-and-so, first Indian reported so-and-so, my lord, the law of the points has been stated thus: most states claims a legal theory to exclude all aliens at will, affirming that such unqualified rights is an essential attribute of sovereign government. The Court of Great Britain and the United States have laid it down that the right to exclude alien at will is an ancient territorial sovereignty, unless bound by an international treaty. Yes, or incident of territorial sovereignty. Unless bound by an international treaty to the country, states are not subject to duty under international law to admit aliens, or any duty thereunder not to expel them, nor does international law impose any duty as to period of stay and admitted alien. Now, like the power to refuse admission, this is regarded as an incident of the state's territorial sovereignty. International law does not prohibit the expulsion in mass of alien. Reference has also been made to the Article 13 of the International Convention of 1966 in Civil and Political Rights, which provides that alien lawfully in the territory of a state party to the covenant may be expelled only pursuant to the decision reached by law, and except where compelling reasons of international security otherwise requires, is to be allowed to submit the reasons against the expulsion and to have the case reviewed by and to be represented for the purpose before the competent authority. Now, my lord, this part. It is important to note that Covenant of 1966 would apply provided an alien is lawfully in India, namely with valid passport, visa, etc., and not to those who have entered illegally or unlawfully. Similarly, similar view has been expressed in so and so. The author has said that the reception of alien is a matter of discretion, and every state is by reason of territorial supremacy competent to exclude alien from the whole or any part of the territory. In para 413, it is said that the right of states to expel alien is generally recognized. It matters not whether the alien is only a temporary visit or has settled down for professional business or any other purpose in its territory, having established its domicile there. A belligerent may consider it convenient to expel all hostile nationals residing or temporarily staying within its territory. Although such a measure may be very harsh in individual alien, it is generally accepted that such expulsion is justifiable. Having regard to Article 13 of the International Covenant of Civil and Political Rights, 1966, alien lawfully in state territory may be expelled only if pursuant to decision reached according to law. Well, here is the case. That's why I brought my law. In our cases, they have not entered with valid passport, valid documents, and their documents has been expired. For that reason, they become illegal. There are two categories, my lord. One is validly entered foreigners, one is illegally entered foreigners. These foreigners are illegally entered foreigners that have no documents that they have entered from Pakistan with valid documents, and after some period of time, their documents have been lapsed, so they will get a proper procedure of law. Despite of this, my lord, in fact, we provided procedural safeguards with forming the foreigners team, giving them opportunity to prove that they are not foreigners. In fact, this international convention has not allowed that. It is said it is the state who can expel them immediately without any procedure, however harsh it may be. But here is the case, we given a procedure, we allowed them to contest. In fact, they have availed, they went to the tribunal, they have taken enough time, they came to the High Court dismissed, filed appeal, that is dismissed, filed review, that is dismissed, went to Supreme Court, that is dismissed. Now they are saying, no, we cannot be deported. What is this? In fact, we have given enough opportunity. They have taken enough opportunity. Whatever, in fact, though there is no right given, they have been given enough right, apart from this. Now, the Supreme Court, thereafter, your lordship may kindly see, other things are also there. Then your lordship may kindly see what is in the United States, USA, para 77. 78 may also be seen, my lord. 77, it is said in United States also, same procedure is followed, my lord. 78 it is said, my lord. Para 78 may kindly be seen, my lord. This is referred to the earlier judgment of 1991, my lord. Louis D. Reddit, where it is said. The law points here, my lord, in the second line. Then they challenge the order by filing a writ petition. And the textual aspects were there. They challenge the order by filing a writ petition. This court held it power of the government of India to expel foreigners is absolute and unlimited, and there is no provision in the Constitution fettering its discretion, and executive government has unrestricted right to expel a foreigner. So it is, well, there is no condition at all. So far as right to be heard concerned, there cannot be hard and fast rule about the manner in which person concerned has to be given an opportunity to place his case. I mean, we are giving a procedural law where they have got enough opportunity. In fact, they have gone to the Honorable Apex Court also. Then para 79 it is said, my lord. I'd like to read last part of the para 79. State reserves right to expel them from their territory and to refuse to grant them certain rights which are enjoyed by their own national, like right to vote, hold public office, or engage in political activities. Aliens may be debarred from joining the civil services or certain profession, or from owning some properties in the state, may place them under restrictions in the interest of the national security or public order. Nevertheless, my lord, this part, once lawfully admitted to a territory, they are entitled to certain immediate rights necessary to be enjoyment under ordinary private life. Thus, my lord, the Bangladeshi nationals who have illegally crossed the border and have trespassed into Assam or living in the other parts of the country have no legal right of any kind to remain in India, and they are liable to be deported. These are admitted facts, madam. And the Supreme Court in Sobananda Sunwal itself says, lay down that those has to be deported. And now they are saying we cannot be deported even though we are declared foreigner. That is not the law, my lord. Then, my lord, sit down. Then recently, my lord, in my lord,
May I just submit two factual, just two factual.
so you'll get the opportunity.
No, I'm not just, just two factual, just afterwards. No, no, no. No. Appeal.
I have one copy.
I'm deeply, I'm deeply apologize, I'm still learning, I'm deeply apologize. I'll sit, I'm deeply apologize.
This judgment, my lord, I could not got two copies, my lord. Here is the case, my lord. You also will find. This is the in Rajabala Das case. 4/2/2025 order, my lord. My lord, para 2, that aspect, there is some light on this issue, my lord. Para 2 of this. Today on one more affidavit dated 3rd February 2022 is filed, which is vague as earlier affidavit. We have produced the annexures to info. When we asked a question to the Chief Secretary of the Assam, is present through video conference, whether the nationality of the persons listed or serial numbers 1 to 63 is known, or he answered affirmatively. As it is known that the person with serial number 1 to 63 are citizens of a particular country, there is no reason why state of Assam cannot start procedure for their deportation. Even if address of those persons in the foreign country is not available, as the state is aware that they are citizens of particular country, we direct the states to immediately start process of deportation in respect of the person serial number 1 to 63. This part, madam, why I have argued 6A, madam. That's why. It is the Honorable Supreme Court has said, we know the state of the original state of the particular person concerned. Because he is under 6A only. So nation is known. Even though address is known, we can deport them. Even though address is not known, we can deport them. Nothing. So, but that must only, my submission is that from this, my lord, it is clear that in case of deportation, there is no prohibition. In fact, my lord, the another aspect was that the Honorable Apex Court has run them bail, so they may not be deported. That aspect is not there because the Honorable Apex Court in my lord 1047/2018 has not prohibited my lord deportation. That I have compiled in the my lord my argument. That much.
Anything in reply?
Yes, your lordship. Minutes, first minute, minute, I received the written arguments in there. They have alleged that that my mother was deported on 25. So I need the 24/5 2025. Because this is the story that that the state is coming just right now because this case is pending since 2 months, and from there, from time and again, your lordship has passed order, and it's only now that they are filing. So I need I'll be challenging this. Like, so I'll be filing a affidavit on in this regard, like, in this factual aspect. It's two things on just two corrections. In both the matters, we haven't reached Supreme Court yet. Now we have before the Honorable Supreme Court in Majeda Khatun, I have the diary number. So the contention that the Supreme Court dismissed it, it's factually wrong. In Majeda Khatun, we went to the Supreme Court. Supreme Court gave us the liberty to go file a review, and also the liberty to, if the review is not allowed, you again come before the Supreme Court. So now we have approached before the Supreme Court. We have the diary number. The matter will be listed in 2 weeks. We are hopeful. Now, other aspect on it. The sovereign power they of course have the power to deport anyone, a foreigner. A foreigner doesn't have the right to stay in a country. So that we are not challenging. What we are challenging is the procedure and the manner in which a foreigner has to be deported. Foreigners Tribunal's order. Now, I'll just summarize what I said, and that's how does my argument doesn't learned senior's argument doesn't respond to my contention. I say that they have the power, but that power was not exercised. The power is there in section 32G of the Foreigners Act. There is no order, specific order on that respect. So once a reference is given to a SP order, SP order gives a reference to the Foreigners Tribunal under section 3 of the Foreigners Tribunal's order. After that, the Foreigners Tribunal order passes an opinion. Once the opinion is passed, it's full stop, it ends. Then it goes to the referral authority, Deputy Commissioner and SP border. Now, once the SP border, now after the foreigners has been declared as a person has been declared as a foreigner, that's where the jurisdiction of the Foreigners Tribunal ends. It doesn't has the power to say from that point onwards to detain him or to deport him. That will have to be another separate order has to be passed after looking at the facts, after application of mind by the concerned authority as per section 3(2) of the Foreigners Act of 1946. And if we pass that order, we saying after that order hasn't been passed in my case, in both the cases. Now, after that order has been passed, it has to again comply with Article 22 of the Constitution of India, and in which regard, I am placing before your lordship a judgment. It was State of Uttar Pradesh versus Abdul Samad and another, if I may, madam. It's one of the earliest judgment in which it's a 5-bench judgment of the Honorable Supreme Court, in which Honorable Supreme Court first elucidates on Article 22 vis-a-vis the rights of the foreigner. If the foreigner has a Article 22 rights or not. Well, so I'll be relying on 2 judgments. In this case, Yes, it's in this case, well, it's the High Court of the Allahabad High Court gave a bail saying that these two person deportation order was passed. They were taken to the Jaipur. Meanwhile, while they were taken to the Jaipur, police receives and they file a petition before the Allahabad High Court. Allahabad High Court says that since they have outside the jurisdiction, we can't pass any order. So, meanwhile, something happened. They are again brought back. And when they brought back to Allahabad into the jurisdiction of the Allahabad High Court, their petitioner again approached to the Allahabad High Court. The Allahabad High Court held that the reasoning that they gave is in the first order, since it was a deportation, it was a detention. So the petitioner argued that I was not produced before the magistrate within 24 hours, which is mandatory under Article 22. The Honorable Allahabad High Court make two distinctions. They say that a deportation, a detention for deportation, and a deportation for custodial interrogation. So while detention for deportation, the person might not has to produce before the magistrate, but if there is a detention for custody for further interrogation, he has to produce before the magistrate. Now, in this, the Honorable the dissenting opinion of Justice Subbarao, he has completely disagreed. That is at page, if I may read. Let's page para 20 minutes. Page 10. And then I'll be coming to the larger the majority opinion minutes. If I may read. Let me read minutes. That apart, I am also not satisfied that the conclusion arrived by the High Court is wrong. On the said fact, the respondents were admittedly not produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate. Such persons could not be detained in custody beyond the said period without the authority of a magistrate. This is an allegation that the respondents were produced before a magistrate at Amritsar, but that magistrate did not satisfy the definition of magistrate in Article 22 of the Constitution. Now, I find it difficult to dissect the detention into two periods, namely the detention for deportation and detention for production before the High Court. The act of detention was a continuous one, and it did not cease to be one for the purpose of deportation by the fact that the respondents were back to Lucknow and thereto to the High Court pursuant to the notice issued. The question, therefore, is whether such an arrest for the purpose of deportation is outside the ken of the constitutional protection given under Article 22(2). Indeed, the state of Uttar Pradesh in its petition for special leave contend that the detention was for the purpose of deportation and therefore not government by the said provision. The material portion of the article read, it's the entire quotation of Article 22, which I am not reading, Then, now let's second, it would be seen that under this provision, there is a constitutional injunction that a person arrested and detained in custody shall be produced before a magistrate within the prescribed time. It cannot gainsay that arrest and detention in custody in contravention to this provision is illegal. Clause 3 of the article specify two exceptions to the said injunction. Admittedly, the respondents did not fall under one or the two exceptions. The constitutional provision is couched in clear and unambiguous phraseology, and it is not permissible to read into that provision exceptions other than those specially provided for. When a provision issues an injunction in clear words and provides for two specific exceptions, it must be held that it prohibits any other exceptions. So, the exception here is only two exceptions in Article 22. Is there any person who is an enemy alien and who is being arrested under preventive detention. Now, in our case, there is no order under 32G of the Foreigners Act. No order was given to me. Article 22 flagrant violation of Article 22(1). And now, since so we are only to summarize, what we are saying is the procedure and the way in which it has been challenged. And my senior is absolutely right, we are facing with a unique position here. This judgment is a 1962 judgment. In this 1962 judgment, after that, there has been Menka Gandhi judgment, the other sort of lines of judgment, constitutional judgment, in which they have read Article 14 to Article 21 and 22, and which there has been a host of emergence, constitutional developments vis-a-vis with the rights of foreigner. Now, let's I'll speak on I'll submit on a larger context on why I think your lordship should intervene. Suppose a person comes under in the year 1973. Suppose a person has come because the cutoff there is 1970. No, if the person comes under 1973 and he is illegally entered, let's assume that he is illegally entered. Now he or she has come and he has stayed in India for now 50 years. While staying in India, she has given birth to an Indian citizen. She has given a birth to a child. She is married to an Indian person, and she has given to a birth to an Indian child. Now that child is an Indian citizen by virtue of a citizen by birth. Article 3, 4 of the 4 and 5 of the Indian Constitution. So
We are not concerned who is the person who has married an Indian, had been living here for 50 years, whether his son or daughter is an Indian or not. That is not a question we have to decide. For that, you have a different platform.
No, man. What I am saying here is the entire contention of my learned senior is what I have
We'll
understood.
deal with it when it comes.
No,
We are not answering anything which is not pleaded.
I am in both the petitioners. They are here, they are Indian citizens. There is no reference against both the citizens in both the petitioners. In both the petitioners, their mothers has been declared as an Indian. So since there is no case against me, I am an Indian citizen. Both the petitioners, in item 19 and 20. So I am an Indian citizen. Now my mother has been declared as a foreigner, and we want to challenge. So so that's the aspect whether I as a petitioner I have any right or not of my mother and my mother. So that's why here is making a distinction, and that's why I think this factual aspect is necessary. And also, I will be filing a reply to this. No, it's because no, because this is
It's a written argument, not it is written argument.
no, but if this is a very serious, it's completely prejudices my case, man. This is only the first time. This habeas corpus is pending for 2 months, man. But this is only now that they have submitted that I was deported. But, I'm deeply I didn't mean to antagonize. I'm deeply apologize for that. On the next, I'm just submitting just one thing. I'm just the diary number, just diary number, I'm giving diary number. The case is we have filed the Supreme Court. So we're just giving the diary number. Just make deeply apologize, Manoj. I'm still learning, Manoj, at your lordship's foot, Manoj. So I'm still young, Manoj. I hope you pardon, Manoj. I understand, Manoj. Learning, Manoj. I'm deeply ignorant. I'm still learning when it's I'm deeply ignorant. I'm still learning when it's I think I'm deeply organized. Let for my inexperience, let not my clients suffer. I just that's a humble. Rather, I leave it before your lordships. Your lordships will do it. Much of it.
Yes.
Yes.
Same.
Item 21 is from
19 and 20.
Item 1 for hearing.
May I please? Impin order is page 73. Here is DW1 petitioner number 1. DW2 is the Gavura. DW3 one headmaster nearby house of the petitioner. Of page 70. And in this case, my lord, the tribunal did not give any finding on DW2 and 3. My lord. Yes. And Judge this case did not give any finding. Yes.
And then at page 76, there's a discussion on the evidence of PW3.
Here. Chanmia. OPW3 Chanmia, who knows the OP, Ahmed is wife and children. In this case, my lord, reference only against petitioner number 1, my lord. Talent, according to him, the name of father Razia Begum so and so. He proves the voter list 6 is raw constituency for the so and so. Ms. Shahzulaka,
This reference against one only.
Yes. Only discuss Miller. Para formula discrepancy in the names of father of the petitioner number 1. Apamia Anamia.
Correct, because after 65, your father has no existence. There's, what happened to him, we don't know. Yes, Mr. Payne. The reference is only against one, so reference has to fail with the
Which other,
opinion has to fail with regard to others.
others?
But Mr. Ahmed,
Miller.
please come to your written statement.
Page 56.
56.
Yes.
Now, see, if you, in your written statement, that difference is not taken.
A written statement, Miller. Then taken, Miller, inquiry is not properly done.
Page
sir.
56.
Yeah, yes, 56.
No, not properly done is an inquiry, but there is no reference against them because you contested the matter,
Yes.
knowing fully well what is available. Although there is a judgment which says that the tribunal would have jurisdiction only when there is a reference. But what happens if you give your acquiescence to the proceedings and you contest it? Since there is no reference, we are unable to accept this opinion for others. The Superintendent of Police, if required, will give us separate reference against them. But insofar as the petitioner number 1 is concerned, we don't find anything to connect him to your projected parents.
79 nothing. 79. Yes. Page 20. Page 28 millet one voter list 1979. Ahmad Ali. His name appear along with his mother. And mother name is appear in voter list of 1971, page 26. Voter list 1979, page 28. And petitioner number one's father name, grandfather Milord. Here is father's name appear in voter list of 1965, page, yes, page 24. Mother name appear in voter list of 1971, page 26. Same village. At 21 is the annual Khiras Patani. Here is Milord Moja Goba. Yes. That is the discrepancy in the name, Milord. Yeah. Yes. Amen. In Anamia, Apamia. No. Aparta is correct, my lord, or name is wrongly written. And 65 voter list, my lord, page 24, here is Apami. And 65 is voter list of 19, page 24, Apami, grandfather name is Moniruddin. And voter list 1971, mother name is appeared. And petitioner name appear in the voter list of 79 along with the mother name. Same village. 79, 89. And that transporter may be discarded mill, kept millot and other remaining 65, 71 voter list remain here in 79, 89. And moreover, in this case, millot, evidence of DW 1, 2, and 3 millot has not discarded by the state authority and did not give any finding on the deposition of DW 2 and 3 millot. On that count, millot, the matter may be demanded back, millot. Some days back, millot, in the case of Jamila Khatun, millot, the matter demanded back on the ground that the tribunal did not give any finding on the evidence. Mill. Jamila Khatun, careful.
You
Gaupura
have exhibited a
certificate is
Gaupura
page
certificate, where is that?
41. Page 41. Ahmad Ali Kita Anand.
Is it page 41?
Yes, Gaupura certificate.
Did he come and depose?
Yes. DW2, my lord, page 68. Barnacular, page 69.
I'll try to read it. Nineteen 68. যিহেতু অসমৰ ভূমি ৰাজনীতি আইন আৰু সময়ে কৰা তাৰ নিয়মৰ বশৱৰ্তী হৈ ইয়াৰ লগতীয়া এই তফচিলত লিখা মাটি আপুনি দখল কৰিছে, তলত লিখা চৰ্তমতে আপোনাক 1968, it seems to be 68, my lord, and 69, 68, 69, yes, চনৰ ৰাজহ yes. Seems to be 68, 69. Below it is 1375.
Yeah.
Annual-
Annual kirat pattern.
Yes,
69.
Yes.
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 Okay. 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 Yes, it's family calendar.
Yes.
As per record Miller.
It has to be, Malad, if it is annual patta, the patta will be for every year, man. Only 69, 70 will not, 69, 60, 66, 68, 69. Yes.
Yeah.
Yes. Yes.
Yes. 1968, 69 চনৰ ৰাজহ বছৰৰ কাৰণে for 68, 69.
Yes. Patta will-
Yes.
I'll show some other things also, my lord, apart from this. That is probably with regard to my lord Apamia and Anamia, that projected grandfather.
No.
Yes, Anamia,
Anamya Patak.
Apamia, Anamia.
Moniruddin.
One interesting fact, my lord, he did not submitted the documents before the tribunal, 1979 could release. That was not exhibited one. Probably there is some reason.
No,
Yes.
actually not.
In his cross, my lord, while before the tribunal, he said his age is 65 in 2015. Yes. Your lordship may kindly see the WS at page 60, my lord. Written
Yes.
statement. It's totally a vague statement, my lord. This does not contain, first of all, my lord, what is his year of birth? I'm not asking the date of birth, even the year of birth or probable, my lord, year of birth, nothing. He has not described anything. Nor he has discussed, my lord. He has indicated where is his place of birth, and he has not disclosed the name of the mother, my lord. In the entire WS I have seen, he has not disclosed the name of the mother. This is very important because my lord, my learned friend did not submitted the document in the 79 voter list before the tribunal. Now he is relying that, but he is not. He did not submit that. According to him, his mother is there in the 79 voter list, and his name is appearing in the 79 voter list. 71. 71 is also not submitted before the tribunal.
No, yeah, exhibit 4. T8.
So, WS4. WS4. Yes. 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 No, this is it. That is true, my lord. Yes. Yes,
Oh,
definitely, my
yes,
lord.
my lord, only here, similar.
But nowadays, the birthday is celebrated. So from childhood itself. So they don't
Only for enjoying the birthday.
Yeah. No, what my submit, my lord, even though he put that.
নাই কৰা নাই। Yes,
My lord, we are dealing with Ahmed Ali only, petitioner, my lord,
yes,
one.
yes, yes.
So your lordship may kindly see from either in WS he has, why I have said, I'm saying this, my lord, I'm submitting this, because he has not disclosed his date of birth. Neither he has disclosed the age during the time of my lord filing this WS. He has filed this affidavit of this, my lord, this on oath, my lord. Page 63 is the oath. Mohammed Ali, it does so and so. Age is not disclosed. This is important because he has not disclosed his date of birth. Mother name is not disclosed. But now he is claiming that his mother is, my lord, one Apida Begum, whose name is there in the voter list of 1979, along with the project petitioner, which was not exhibited document, which is not an exhibited document. Yes, 79 was not exhibited. 79. 71, my lord, WS, he has not mentioned about 71. That, yes, he has not mentioned in the WS, nor in his evidence he has mentioned about 1971 bitterly. Yes, in 71 also he has, my lord, the base, yes, mother name is not said. Page 66, the evidence. And
71 মানলাম নাই।
he has not mentioned about 71.
তাৰমানে নাই, আপিলা থাকো।
Only he said,
কিন্তু ৰিলেশ্যন নাই বুলি মানে নাই ক'ব নোৱাৰে। 26.
only thing your lordship may kindly see page 66.
সেইটো মাৰ নাম পোৱা নাই, সেইটো কাৰো ক'ব নোৱাৰি।
Yes, page 66, your lordship, this is the evidence. And this page 60 is the WS. WS he has not mentioned about his year of birth, his probable age. Page 66, only at the time of pilot taking oath, he has stated the deposition of OPW2 is it about 65 years. This is the first time with the age of the petitioner is, my lord, disclosed by him.
Where?
Page 66, man. Now, if we calculate, my lord, he is at about 65 years in 2013. His date of birth will be sometime in 1948. And he was eligible to cast vote in 1969 itself.
Yes.
Then, my lord, the mother, projected mother, according to my learned friend, page 26, the voter list of 1971, it is a, she was, my lord, aged about 23 years in 1971 as per. And her date of birth will be sometime in 1958.
Okay.
So, the petitioner is born in 1948, mother is born in 1958. If it is true, man. Of course, this document,
Old document, no?
and one Ahmed Ali, though this document, the 79 voter list was, that's why, my lord, I said, my lord, this document was not in, submitted before the tribunal intentionally, because in 1979 voter list, it is one Ahmed Ali is there. He was aged about 22 years.
No, just a moment. You are trying to is in the evidence,
Yes, ma'am.
page 66,
Yes,
he's, this is
65.
on 2013,
yes,
he's 65 years,
yes,
therefore he's born in 1948.
48.
Now, page 26,
Yes, ma'am.
if in 1971,
Yes,
one is 23 years,
yes, madam.
then date of birth would be 1948, same year.
No, madam. 71, it was 23.
71 is 23, so 1948.
Yes, 48, 48, sorry, 48,
Would be 48.
48, sorry, 48.
Okay. Also, that makes it unbelievable.
Same year, madam, date of birth.
Okay.
This is, my lord, either in the certificate, any certificate, my lord, either in the Gaobura certificate or in the, my lord, concert certificate, age is not disclosed. Even in the WS, while filing WS, though oath is met, that was without any, my lord, age. And even, my lord, he has filed an affidavit to correct the, so the correction of the, to correct the name of the father in the voter list. There also, he has not disclosed the age of the petitioner.
Where is that?
That is. Let's be fine. 36. Yes. 36 is the affidavit. Moy Ahmad Ali, Peter so and so, but age is not disclosed.
अंगूठा हमारे इसका।
First time he disclosed in the, during the time of evidence that he is 65 years in 2020. So it is unbelievable, my lord. Secondly, my lord, he is trying to say is that the projected father is in the voter list of 1965 at page 24, my lord. Apamia. His projection is that this Apamia is the father of the petitioner number 1 in the instant case, madam. And this Afia Khatun is the mother, even though that is not disclosed anywhere in the WS and evidence. Only at this stage, he is saying this Afia Khatun is the mother.
Just a moment. Yeah. Yes.
My lord, your lordship, may kindly see page 24. This is the voter list of 1964. Here the voter is Apamia, father is Maniruddin, aged about 40 years. Then he is saying this exhibit, my lord, page 25. This is voter list of 1970. Page 26. Afiza Khatun is projected to be murdered, though it is not mentioned anywhere in the WSN evidence. Now, neither in the WS matter nor in the evidence, he has disclosed what happened to this Apamia after 1965. What happened to this Apamia? Where he has disappeared, man. Not a single voter list of documents after 1965 of this Apamia, either with the projected murder or with the petitioner or individual. And what happened to him, that is not disclosed anywhere.
Yes.
Thereafter, my lord, only he exhibited the voter list of 2005 containing the name of the petitioner. This 79 voter list is not exhibited. Only, in fact, yes, not exhibited.
What are the exhibited documents?
That is 65 voter list, my lord.
Uh,
Exhibited.
Huh? 65. Then, my lord, even though he did not exhibit, my lord, the Kavura exhibited something.
Just a moment. In this, Pata is exhibit Q.
Ko. It is exhibited by Khalik Hussain, ma'am, not by the petitioner. Khalik Hussain is the Kavura. Pata is exhibit 1. My lord, exhibit Ko is the annual Kiras Patta. Exhibit Ko is the certificate issued by the Kaubura. Exhibit Ko is the certificate issued by the president of Saliguri Gaon Panchayat. Exhibit Ko is the family identity card issued by Hagdafa Cooperative Society. Exhibit Mo is the birth certificate issued by registered birth and death PEC in favor of Azina Begum. And these documents are exhibited by OPW2 Khalik Hussain Hassan, the Gaonbura.
Is there any document, Jha,
Yes, my lord.
exhibit Jha?
So,
Jha,
Yes, Jha. Yes,
What-
madam.
What is that?
Exhibit Jha, birth certificate. Birth certificate of the, madam, other petitioners, of the other petitions.
No, no, no. Jha and Jha are three birth certificates.
Yes, madam.
What is
Jha are the three birth certificates. Of the, madam,
What is Jha? Jha.
Jha is the transfer certificate.
Hmm?
Transfer certificate. The school certificate, the school transfer certificate of Mohammed Shahajuddin. This is not related to us. Then DW3 exhibited some other document, madam. Exhibit Neo is the voter list of 1965. This was exhibited by the Gaon Panchayat Secretary. High school, no? School head. Okay.
This,
Yes. Exhibit Neo is the 1965 voter list.
who is DW, the
DW3.
OPW2, Khalek Hassan, who is
He
he?
is the Gaon Bura, madam.
Lad Gaonpura.
Yes. Hello. He came now. School. Everything.
This OPW3, he is proving the 1965 voter list.
Yes, madam.
PW3 is
School.
PW3 the Chan Mohammed.
Son Mohammed.
He headmaster of the.
who is he?
Page 71 million.
School teacher.
School teacher.
School teacher.
I know the respondent, Ahmad Ali, his wife and son. There is a house near the school in which I work. Ahmad Ali's father name is Anamia. Reja's father name is Penso.
He exhibited exhibit Neo. Neo is 1965.
65 voter list.
Exhibit To, 71 voter list. Then exhibit To, voter list of 2005. Exhibit To is the revenue receipt certificate, my lord.
Exhibit To is
To, TA To is 71
Akida
voter list.
Akida Kati. Banekula Akida.
then what will be Tho?
To is the voter list of 2005 of Jagirut constituency.
Yes.
Then Do, my lord. Do is a revenue receipt certificate receipt issued in favor of Ahmad Ali. This should be Do, my lord. DHA. Do is the school certificate in favor of the, or is it Cho? Do is the school certificate in favor of Sajuddin. No is a registered registration card issued by SEBA in the name of Rizal. These are not related to the petition.
No is what is that?
No is registered card issued by SEBA.
Registered?
Registered card.
Oh,
madam.
registration card.
Yes, registration card. No.
Yes.
Registration card issued by SEBA in the name of Rizal. These are the documents. No, interestingly, my lord, the 71 voter list and the 70 voter list 65 voter list, and 2000 voter list. And birth certificates, birth certificates are not related to the present petitioner. These certificates are exhibited by the government, not by the petitioner. So contents of these documents, what is there in the contents of this document, this is not proof money. And even though we accept, my lord, these documents are there, my lord, 2005 voter list, if your lordship may kindly see. This is the first voter list of the
Page
petitioner,
31.
my lord. Page 31, 32, my lord. 32 is the vernacular.
Elected.
This is the first voter list of the petitioner, Ahmed Ali, son of Anamia, is aged about 35 years. So we are concerned with this person only, my lord. So this no way relates the petitioner to his projected father, my lord, Apa Mia of 1965 voter list, is 24.
That is which page?
This is page 32. Page 32 has to be related to page 24, my lord. Apa Mia. In page 32, my lord, 2005, neither Apamia is a voter nor his projected mother, even though it was not mentioned, nowhere mentioned, my lord, in earlier in the court below, in the tribunal below, my lord. Nowhere related to Afia Khatun. Even Afia Khatun name is not there in the 2005 voter list. And he has not disclosed, once again I will say, my lord, and there is huge discrepancy in age, my lord. Because if this person, Ahmed Ali, who is a voter in 2005, was aged about 35 years, my lord. His date of birth will be sometime in 1970 only. And 70, Apamea is not a voter. 70, Apamea is not a voter. His presence in the 1970 is not there. Because in 70 voter list, even though it was produced by some other else, in 70 voter list, his father is not there along with mother. Father is also not there along with his mother. Nor mother is there in the 1965 along with father. So both are in separate. Now, with regard to the discrepancy in name, my lord, he is claiming that in the 2005 voter list, my lord, his father's name is mentioned as Anamia. And that similar to, that is the Apamia whose name is there in the voter list of 1965. That is his claim. So who will prove that? Who has proved that? Whether by any documents, by any evidence, my lord. There is no proof that this Apamia and Anamia is the same person whose name is there as a relative of the petitioner in 2005. This is why, my lord, one may enroll his name in the voter list by giving some other's name. That I am so and so, my father name is so and so. The father name may be adopted anyone's name. My lord. There is this my lord, Anamia. He may have adopted this Anamia as his father. While enrolling his name in the voter list in 2005, he may have thought that my father name is mentioned as Anamia. Had there been Anamia as a voter, in 2005, and this Mafida, my lord, this Afida Khatun were also voter in the same voter list in 2005 or prior to that, along with the petitioner. One of that we could accept it. Yes, it may be. Then also there is some problem, my lord. Anybody can come and there is some manipulation, it may be, but we are ignoring those manipulation, whatever it may be. But then we could accept, yes, at least they are in the same voter list, they may be in the same house, so they are relative. If that document is not there, even in Kematullah also, my lord, in
Applicable in the
Sirajul Haq,
Anamia.
Sirajul Haq also, the Apamia could have been accepted at Anamia. Had there been other voters, my lord, available in the same voter. Because that was qualified by some conditions that other names in the same voter list are consistent in other later part of the voter list also. So that can be accepted as it, that there may be some spelling mistake. But
We'll
here
continue
is no,
to-
it is not there. ma'am.
we'll continue to because we have back-to-back two meetings.
Yes, ma'am. That must only, ma'am.
Okay.
I have no more. Only.
To say,
My lord,
we will continue at 2 because I have a meeting right now at 1.
then my lord, other day may be taken.
For pronouncement of judgment, WBC 3266/2025.
Uh, In this case, we have found that there is an incorrect statement in the writ petition. We have given the description of what is the incorrect statement in the writ petition. And therefore, we had to spend a lot of time to find out the incorrect statement made therein. And accordingly, the delay is found to be not properly explained, and therefore the ground of delay and laches, the writ petition is dismissed. But please take care. Always we may not be so considerate. There is absolute false statement made in the writ petition.
Miller. Petitioners, other name Apamia and Anamia Miller. That part is admitted by my learned friend in the name of discrepancy, which is relating the case of Shirazul Haq Miller. That is already Miller decided by the Supreme Court. I'm on that, my lord. In this case, Miller, DW2, who is the Gabura Miller, and he has exhibited, he has proved some documents. And Miller, one school headmaster, DW3, he has also exhibited some documents. Miller. These evidence are not rebutted by the state authority, which is admissible as per division bench judgment of this honorable court, Abdul Khalek, State of Assam, and other. Miller, in this case, Miller, Tribunal did not give any finding on DW2 and DW3 Miller. And on that count, Miller, a matter may be remanded back to the Tribunal for fresh opinion, Miller, in terms of the judgment and order dated order for passing the Jamila Khatun Miller 2 days back, Miller, by this honorable court.
Can you elaborate about the finding you are referring to of PW 2 and 3?
Yes.
What do you mean by that finding?
Finding Miller only discussed, but did not discarded the evidence. Only discard 2 and 3. Page 75, DW, OPW2 Miller, Khalik Hassan, Ladgabura, only just discussed, and DW3 also Sand Manur, but is not discarded. And state authority Miller has not raised any objection or raised any question about the authenticity of the any documents Miller.
You see, there are several reported cases in the GLT GLR where there was a ex parte suit. Suit was dismissed by the trial court. Came in first appeal, the first appellate court dismissed the appeal. It came in second appeal, even in second appeal, the suit was, the dismissal of suit was upheld.
That is the civil treatment in this case,
No,
citizenship
I'm not on
relation.
I'm not on the facts, but only the principle.
Hmm.
Is it so bad that a case, when it is decided and there is no objection to the evidence, can it be so bad that the proposition cannot be rejected at all? I'm on the question of law, not on the civil application of CPC. I'm just giving you an example. My examples are always horrible. So excuse
I
me
have
for
no
that horrible
knowledge on
example.
about civil case. Miller.
But
I have no knowledge.
the question of law is, even if there is no cross-examination, can the evidence not be discarded? You see, when you refer this to us, first thought is, I'm sorry to say, I come again back to the CPC. Order 18 Rule 3A. It says that the person concerned must be the first witness. In your case, none of the documents were exhibited by you. You are the proceedee. You don't exhibit a document. The document is exhibited by a school teacher, a headmaster, or the Gaubura. First question is, how will they have custody of your documents? Your voter list, what is that doing with
Hey guys, welcome back to Practical Solutions. In
oh.
this video, I'll show you how to connect Windows 11 to project. In the first step, go for full.
How do you expect us to believe that your voter list will be with the Gaura, and to accept his evidence that the name of A should be read as B, Now there's another situation. You'll have to tell us. Witness A comes in a case and he says, let us take a criminal proceeding. He comes and says that I saw ABCD present there. B comes and says that I saw ABCD. This man, first witness says that he saw it in the High Court building, that these 4 people, ABCD. Second witness comes and says that I saw them at, say, Uzan Bazaar locality. They were assaulting Z. Witness C comes and says that, well, they were assaulting not with hands, but they were assaulting with sticks. Police investigation says that we found nothing. The investigation did not say anything. There is a FR. And against FR, a complaint is made. In a complaint, the witness comes and says that, well, fourth witness comes and says that the witness number 2 said that he was assaulting with a, 3 says that he was assaulting with a lathi. These are the lathis by which he was being assaulted. And so this is an exhibit in the complaint case. Now, how do you connect all these 4 and say that this man is guilty beyond reasonable doubt?
Yeah.
4 people are together in the High Court, 4 people were assaulting there. So these are independent witnesses. It doesn't connect and make out a crime.
These
Few days
two-
back, we accepted argument of Mr. Uddin and then we acquitted them from death sentence. No, sit down. OPW3, he is
School teacher of the petitioner's place,
yes.
page 71.
And you see, he produces a registration card issued by SEBA on behalf of the person. This school teacher or the school headmaster will not have custody of the registration card. It is given to the student.
Yes, ma'am. Actually, in this case, we would have to examine by the petitioner or by the petitioner's advocate.
Pardon me?
In this case, my lord, as a registration card and other documents, my lord, has to be proved by the petitioner or petitioner's counsel before the tribunal, my lord. That
No,
part
counsel
was
will not
not
prove
done.
anything. Counsel is just a medium who is there to say, to propose a legal argument.
Yeah.
But how will the school teacher have the custody of the documents?
These documents may be, my lord, handed over by the petitioner.
So therefore, it's a
Uh,
secondary evidence being
the
tendered.
hand of the learned counsel, and the learned counsel examine the.
Oh, don't blame the
documents
counsel. They are
for
always
the-
learned.
The DWP and DWP.
Counsel is always
And
learned.
that is happened, my lord, in this case.
Unless you show us where we can delete this word learned.
In otherwise, my lord, the petitioner proved his linkage with the voter list of 2005 in Milo. And he has also submitted Milo ration card, Milo, which is issued by the Government of Assam.
All that by the Gambura.
Gagura DWP case 68.
This is just like this Narega or that card. People have this workers card Actual owners do not have it. They are by the contractors and they get the payment. Sorry, Mr. Ahmed, we are not finding anything in the matter.
In this case, my lord, as per inquiry, my lord, inquiry was not conducted fairly.
Enquiry.
Yes. As per
How you
directed-
say that this is the inquiry was imperfect?
Yes, sir, kindly, uh, a letter of SP Miller, Superintendent of Police Miller, he has directed the SI of Police Miller to inquiry against the Ahmed Ali Miller
Yes.
without any evidence, my lord, without any source, my lord, actually, which is related in the Rahim Ali's case, my lord, paragraph 35, 34 and 35.
You just file a PIL. We'll pass on orders that the policeman can give third degree and find out the answer. Because if
This is the
somebody
question
does
of
not give an
fidelity.
information,
This is not a case of, my lord, other.
if somebody doesn't give an information, please tell us how an inquiry
And
officer is supposed to
In
find
this
out.
case, my lord, without any other evidence, my lord, SP directed the junior officer to conduct an inquiry. What is the source? How he has know the petitioner is come from Bangladesh. And in the inquiry report, my lord, interrogation report, my lord, in bottom during the inquiry, my lord, in the top, my lord, there is no any address from the country origin.
From the country of origin,
The country's origin name is Binga Golai Yes Osva. Itu tuh aku dari kasan itu Google. What yes
it was a report.
di Bharia. Yang apa?
Never mind. Please put on better living. What is the how is the company? Which page you are referring to, please?
Milot.
Which page you are referring to?
Yeah. In this inquiry report, Milot, interrogation report, Milot.
Interrogation report, yes.
It's not actually, you can go.
No, it's okay. Here the address is Bengali PS Kasba district B Baria.
Baria.
That is given. House in the government land since last 22 years. His profession is Rajmistri.
Not government land, Milot. Already, Milot, as per Annexure 1, Milot. Annual clearance pata is there.
Annual pata is
There is
always a
a-
government land. Mr. A.M. Ahmed, counsel for the petitioner. Also heard so for the respondents. Next paragraph, by filing this writ petition in Article 226 of the Constitution of India, the petitioner, namely so-and-so, has assailed the opinion dated 27/8/2013, page 80, type copy at page 73, by so-and-so in so-and-so. They were declaring the petitioner to be a foreigner of post 25 in 1971 stream. Next paragraph. On issuance of process against the petitioner, petitioners, they entered appearance before the learned tribunal and on (29/7/2013), written statement was filed by the petitioners amongst others, stating that the allegations against them are false and baseless, and that the investigation was not carried out properly and was done without any communication with the petitioners, and accordingly, they claim that they are the victims of harassment on false grounds. Full stop. In the written statement, the petitioners have projected that their actual names are page 56, para 4, have underlined. Page 56, para 4. The petitioners projected that they all hail from the same family, and they are residing at village Chakpu Maku, CHAKU, under Jagir Road Police Station in the district of Morigao. First, it has been stated that the name of that late Anna Mia, ANA, next word Mia, MIYA, the father of the petitioner number 1 and the grandfather of the petitioner numbers 3, 4, 5, and 6 is a citizen of India and had come to India prior to 1965, and his name is recorded in the voters list of 1965 of 82 number Morigaon constituency within bracket ST bracket close in the then undivided Nagaon district. And since then, he has been casting his vote. However, his name was recorded as Apamiya, APAMIY, instead of his actual name in the said voters list. In paragraph 7 of the written statement, reference is made to the name names of respondent numbers 1, 2, 3, 4, and 6 stated. No, sorry, 1 and 2 is stated to be recorded in the voters list. So, however, the year of the voter list is not mentioned. So it is stated that the respondent numbers 3, 4, and 6 did not attain the age of age to vote. And in the meanwhile, the respondent number 5 had got married and is residing in her husband's house. The petitioner has stated that they are permanent residents of Assam and have patta for the grant and have certificates issued by the local Gauvura and Panchayat, school certificates, birth certificates, etc. Accordingly, it is projected that the names of the father of the grandfather is recorded in the voters list of 1965 and 1975, and therefore the case instituted against the petitioners should be dismissed. Full stop. Next, in support of the defense, the petitioners had examined the Ahmed Ali, the petitioner number 1 as DW1, Mr. No, sorry, Muhammad MD, Muhammad Khalik, KHALIK, Khalik Hassan, HASN, the government Gauvura of Chakumaku, CHAKU, MAKU, Kisam, KISSAM, since 2004 as DW2, and one Chan Muhammad, CHAN, MAHAMMAD, as please come to page 72. What does it say? Or who is he?
72.
Teacher.
Yes,
He's a teacher,
yes.
who's a teacher by profession. Next para, the petitioner has, first of all, in his evidence, in his examination in chief, the petitioner, the petitioner number 1 as DW1 has stated that the respondent number 2 was is his wife, and the other respondents are his son and daughters. So he has stated that the names of that Ahmed Ali referred in the notice is not his name, but his actual name is Ahmad, Ahmed, and his wife's actual name is Rejia, Rejia, Rejia Begum, Begom, and not Rajia, Rajia Begum, Begom. He has stated that Sabuddin, Sabuddin, mentioned in the notice is not his son, but his son's actual name is Sahabuddin, Sahabuddin. His father's name is Anamiya, Anamiya, but in the notice his father's name is stated as Akbar Ali. So he is reiterated that his married daughter Amina Khatun, who is residing in a matrimonial home, whose husband's name is Mofizul, Mofizul. He has stated that his father's name appeared in the voters list, but instead of Anamiya, Anamiya, his name is mentioned as Apa Mia, son of Moniruddin, in the voters list of 1965. To stop, the DW1 places reliance on the affidavit sworn on 29/7/2013, and he is referred to submission of his family identity card. So he is referred to the Kheraj Patta, KHERAG, Kheraj Patta issued in his name, and the certificates issued by the Gampura and Gaon Panchayat in favor of his father. Full stop. In his cross-examination, DW1 could not remember the name of his grandfather, and he does not know from where his father had come into Assam prior to 1965. Stated that he is illiterate person and is not aware of the current English calendar year. He has also stated that he does not know for what purpose he had submitted the affidavit. And he has denied that he has submitted a false affidavit to save himself of charges. First of all, he has denied that he has not been able to submit any voters list in which his and his wife's name have been recorded. Next para. The DW2, who is the government Gaura, has exhibited the following, has stated that he knows Ahmed Ali, PHMED, Ahmed Ali, his wife Razia Begum, REJIA, BEGUM, and children, namely, we take it from page 68. Children, namely, so and so, so and so. Who are from his lot, LOT, and that the petitioner number 1 is residing in his own land. So he has exhibited the annual Kiras Patta in the name of Anamia, ANAMIYA, son of Inus, INNUS, Inus Munshi, NUNSHI, issued in 1970 as Exhibit K. His certificate as Ghaugura in favor of petitioner number 1 within bracket Exhibit K. Certificate issued by the Panchayat of Siliguri, SALI, Sadiguri, GURI, Kam Panchayat, in favor of petitioner number 1 within bracket Exhibit GA, family identity card issued by Bhagjap, BHAGJAP, Cooperative Society, within bracket, in favor of petitioner number 1 within bracket Exhibit Gho, birth certificate in favor of the petitioner number 6 within bracket Exhibit Ungo. He has submitted that he does not know how to read English. He has stated that Exhibit Cho, and Jho are the birth certificates issued in the name of the respondent number 5, four and Sahabuddin, SAHABUDDIN, son of Ahmad Ali. In his cross-examination, the DW2 has stated that he has not brought any document to prove that he is a government Ghaugura. He has stated that the petitioner number 1 met him at the bazaar, and asked him to come to the court to adduce evidence. He has denied that he is not a government Ghaugura. Next para. OPW3, Chania, Chan Muhammad, MAHA, has stated that he knows the petitioner number 1, his wife and children, whose house is near the school in which he works. It stated that the name of petitioner, the father of petitioner number 1 is Anamia, ANAMIYA. The name of father of petitioner number 2 is Arez, AREZ, MIYAN. Is exhibited the voters list of 1965 of Roha constituency in the name of Arez Mia, AREZ Mia, within bracket Exhibit Mio, NIYO, voters list of 1971 of 82 number Murigaon constituency in the name of Armida, ARMIDA, Armida Khatun, KHATUN, wife of Anna Mia, within bracket Exhibit PA, voters list of 2005 of Jagirod constituency containing the name of the petitioners within bracket exhibit or THA. Comma, revenue receipt in favor of the petitioner number 1 as exhibit DA. School certificate in favor of Sahajuddin, SAHAJUDDIN, son of Ahmad Ali, as exhibit DA. The DA, the registration card of SEBA issued in favor of Riazul, RIAJUL, is in fact exhibit no NA. So in his cross-examination, he stated that in the notice, the name of respondent number 1, you can copy it from page 71, same. Next, the learned counsel for the petitioner. To assail the impugn opinion has submitted that the investigation by the inquiry officer was not done in properly. And several columns were left out and not filled up. It is submitted that although the evidence of PW2 and 3 have been referred to, the evidence has not been discussed or discarded. It is also submitted that the document evidence of the petitioner was had remained unchallenged during cross-examination, and therefore the rejection of the evidence of the petitioners is not sustainable. So it is further submitted that the notices were issued in the name of wrong persons. And accordingly, the reference is defective and the proceedings against the petitioners be liable to be set aside. It is also submitted that the documentary evidence was misread or misinterpreted only on the ground of discrepancy in the name and age of the various voters whose name containing the voters list and that the opinion was passed merely relying on the voters list of 1965 without any discussion on the tenability of the other documentary evidence. Mr. Ahmed, anything we have left out?
Miller.
In the dictation, did we leave out anything?
My pair will be Miller. A tribunal did not give any finding on the DW2 case with 3 Miller. On that town Miller matter may be remanded better.
That we have recorded, already recorded. Anything we have left out? You ask me. So accordingly, it is submitted that not only the impugn opinion is liable to be set aside, but as the evidence of DW2 and 3 have not been discussed, the matter will be remanded back. It is also submitted that there was no reference against the petitioner numbers 2 to 6, and therefore the impugn opinion is liable to be interfered with in respect of those petitioners. Next paragraph. per contract, the learned standing counsel for the FT matters has submitted that that in the pleadings made in the written statement, the petitioner has nowhere projected the name of her mother, his mother. Petitioner number 1 has not projected the name of his, not disclosed the name of his mother. Full stop. Mother or his date of, or his own date of birth, which is required to be disclosed for an effective adjudication of the matter. Full stop. It is submitted that there is no statement either in the written statement or in the evidence of any witnesses regarding the age of the petitioner, the age or date of birth of the petitioner. It is submitted that only while recording the evidence in chief, the age of the petitioner, number 1, is recorded as 65 years. It is also submitted that there are discrepancies of age in the document, exhibited documents, which make the documents unreliable. So it is also submitted that that none of the petitioners exhibited any of the documents. Those documents were exhibited only through only through DW2 and 3. Accordingly, comment is submitted that none of the documents support the projection of the petitioner of being connected to his projected father and grandfather. Petitioner number 1 to be connected with his father or grandfather. Accordingly, it is submitted that the Indian opinion does not warrant any interference. Next para. Insofar as the case of the petitioner numbers 2 to 6 are concerned, concerned. May we take note of the inquiry made by the inquiry officer, as well as the command note issued by the Superintendent of Police within bracket border, bracket was Morigao, directing a particular sub-inspector within bracket border to make an inquiry. Command note dated 3/5/2006. That inquiry report is, it doesn't have a date. As well as the order dated 24/6/2006, 29/6/2006, passed by the Superintendent of Police, Border Morigao, regarding FT case number 207/2006, by which case was referred to the Foreigners Tribunal, Morigao, wherein the reference is made only against Mohammed MD, Mohammed Ahmed, AHMED, Ali. Most of the in this regard, the court is of the considered opinion the court considered opinion that foreigners tribunal would derive jurisdiction, render opinion only on a specific reference being made against the particular proceeding. So in this case, the superintendent of police within bracket border bracket close Morigaon did not make any reference against the petitioner numbers 2 to 6. Stop. The reference is specifically made against Muhammad Ahmed Ali. Stop. Accordingly, the registration of the proceeding against the petitioner numbers 2 to 6 is held to be without jurisdiction, and consequently the opinion rendered by the learned member, foreigners tribunal number 1st, Morigaon in FT case number 157 of 2009 arising out of FT police case number 207 of 2006. It's not found not found sustainable in respect of the said petitioners number 2 to 5, namely so and so. Therefore, one part of the reference which is answered against the above named petitioner numbers 2 to 6 is hereby set aside, and the said opinion shall now only be considered in respect of the petitioner number 1, namely so and so. We don't have time, we'll have to rise, pass the rest of the dictation in the chamber. There was a request made for upgradation of a matter. We have to take it some other day.
Banda.
There was a request made to upgrade one matter. Just stop. Take on my part. I saw the watch wrongly. I'll continue with the dictation. I'm continuing with the dictation. I saw it wrongly. No. It's sign of growing old. Reference being answered against the respondent number 1. We have examined the pleadings as well as the evidence on record. Full stop. At the outset, we take note of the fact that there are 6 petitioners in this case against whom the proceedings of FT case number 157 of 2009 was being proceeded with. Full stop. The documentary evidence has not been exhibited by the petitioners. Full stop. However, major part of the exhibited documents were exhibited by the DW2, who's the government Gambura, and the remaining part of the document evidence was exhibited by the DW2, who's the DW3, who's the teacher. Full stop. There is no explanation by the either by the DW1, i.e. the petitioner number 1, or by the DW2 and 3 as to how custody of the personal documents of the petitioners were within their custody. Next, be that as it may, as shown by the learned standing counsel for the FT matters, except for recording of the form of deposition of DW1, nowhere else the petitioner number 1 has disclosed the name of his mother or his own age or the date of birth. Full stop. Rather, not rather, no, full stop. On examination of the materials available on record, it is noted that the deposition of the examination chief of DW1 was recorded on 16/8/2013, where his age is disclosed as 65 years. First of, therefore, the DW1 was, the petitioner number 1 was born sometime in the year 1948. Full stop. In this writ petition, the petitioner has annexed the copy of voters list of 1971 as Annexure 3. And in the said voters list, the name of Afida AFIDA, Afida Khatun, wife of Anamia, ANAMIYA, is disclosed as 23 years. But therefore, 23. The age of disclosed by 23. So therefore, even if it is accepted for the time being that Afida Khatun is the mother of the petitioner number 1, her year of birth is also 1948. Which is wholly unacceptable, as a mother and son cannot be born in the same year, that is 1948. Stop. On a perusal of the written statement as well as the evidence of the DW1, while it is reiterated that the mother of the petitioner number 1 is not introduced in the written statement, there is also no statement in the written statement or in the evidence of DW1 or DW3 or DW3 as to what happened to Apamia, APA, NIYA, and oblique or Anamia, ANA, projected to the grandfather, sorry, father of the petitioner number 1. Surprisingly, though the DW2 has exhibited the voter register of 1965 as exhibit Kho, but in his cross-examination, he cannot say the petitioner number 1 cannot tell the name of the grandfather. Next paragraph. This comment is, notice that the documents exhibited by the petitioner does not expose the entire family together. First of the Gambura certificate within bracket exhibit Kho, or the certificate by the president of Palikuri Gaon Panchayat within bracket exhibit Go, and the ration card within bracket exhibit Go is not sufficient to prove the existence of any relationship with the persons whose names are contained therein, so as to admit them to be a citizen of India. So neither the DW2 or DW3 has disclosed the source of their knowledge about the documents which belong to the petitioner number 1. The other documents like the birth certificate, which are exhibited as exhibit Ungo, exhibit Ungo, Jo, or the transfer certificate exhibit Jo, also create no link of those persons whose name are contained in those documents with Anamia, Anamia, a projected grandfather of the projected father of the petitioner, or with Apamia, APA, Apamia, whose name appears in the voters list of 1965. Full stop. Next, but there is no document to show that Apamia and Anamia are same one person, except for the affidavit. Which page was that affidavit?
30. 36.
30,
36.
32. 36. It's page 36. 36, this is, was it exhibited? No. Yeah. Actually, the affidavit, which is appended to the written statement. However, neither the said affidavit sworn before the notary public on 29/7/2013 was exhibited and nor it content thereof has been proved with other cogent and reliable evidence. Next paragraph. There is no provision under the Assam Land and Revenue Regulation or the executive instructions contained therein, under which the Lord Gamburas are appointed or to have custody of documents of persons who are residing in their respective lot. Therefore, in the absence of any evidence as to how the said DW2 and 3 had the custody of the documents which are personal to the petitioners, the evidence tendered by the DW2 and 3 would be relevant and admissible as against the petitioners. Next paragraph. The petitioners have relied on the annual Kiraj Pata within bracket exhibit co to show that Anamia, son of Inus, in whose name the annual Kiraj Pata is made, is the father of the petitioner. Full stop. However, in this regard, it may be mentioned that there is no document to show that this annual Kiraj Pata were extended from time to time in favor of the projected father of the petitioner. Full stop. As per the contents of the said annual Kiraj Pata within bracket exhibit co, the learned counsel for the petitioner has submitted that the said annual Pata is for the year 1968-69. And the said, and as per the back page of the said exhibit co, the date of issuance of the said annual Kiraj Pata is (27/6/1990). This must is 1990. 70, sorry, 70. And there's one signature, a eligible signature containing the date of 1970. So there is no explanation as to how an annual patta for the year 1968-69 would be issued post facto. So moreover, the said annual Kiras patta contains the contains a handwritten date of 1375, which corresponds to Assamese year 1375, which corresponds to the Gregorian calendar of 1952. Full stop. It is not the case of the petitioner that his father was in India in the year 1952. Full stop. As stated herein before, in the deposition of DW1, he has specifically stated that his father came to Assam prior to 1965. Therefore, without any pleading or evidence as to who in their family were present in the year 1952, the mentioning of the year 1952 within bracket Assamese year 1375 makes the evidence of the DW1 disbelievable. To show that to show that Anamia, son of Inus, whose name appears in the annual Kiraj Patta, is same person as Apamia, AAPA, Apamia, son of Maniruddin, whose name appears in the voters list of 1965 within bracket exhibit Ho. That resultantly, the nature of evidence which is available on record, the petitioner has not been able to connect himself with an Indian parent whose existence is in the country before 25/3/1971. Full stop. Next, resultantly, the court does not find any infirmity with the impugned opinion dated so and so. Next para. The submission of the learned counsel for the petitioner is that the evidence of DW2 and DW3, those stated in the opinion, has not been discussed. In this regard, having perused the impugned opinion, it is seen that each and every document, exhibited document, have been referred to and discarded as in view of the discrepancies in the names. The evidence tendered, the gist of the evidence tendered by the DW1, DW2 and DW3 have been referred to in the impugned opinion. Most of the learned counsel for the petitioner has not been able to demonstrate how the non-discussion, how the purported non-discussion of the evidence of DW 2 and 3 would prejudice the petitioner in any manner. In view of the specific finding of the learned tribunal that it would be that with such discrepancies in the names, it would be dangerous to confer citizenship to the petitioner number 1 and 2. And in that regard, the learned tribunal had referred to the decision of Mr. Sharma and Mr. Ahmed, please come to page 82. There's a reference to this case, Mohammed Abdul Quddus. Can you identify this case, whether it is a correct citation?
I could not find out.
No, here the reference is Mohammed Abdul Quddus, state versus Mohammed Abdul Quddus. I think there is something wrong.
Yes,
Just
WBC 190 of the.
Is it correct? Is it correct? Then just find out the WBC 190 of 2009.
190 of 2009.
190 of 2009. What is the case?
One 2009.
Abdul Quddus versus State of Assam and others. And date of disposal is
Hmm.
14/6/2010. Abdul Quddus versus State of Assam as a Union of India and others. Union of India and others. State of Assam and others. State of Assam. And just open it up. Is it a foreigners matter? Just open that final order. Is it related to foreigners matters?
No. 14/6/2009 Miller. 7-line judgment Miller. 7-line judgment reflected in the order. Only 7 line. Right. Okay, please. Guru. বন্ধু খুব টাকা আমাকে 8 অক্টোবর till application government approved has produced the law. The letter dated so as per the state letter, the petition has already been deported. So the month of and this is the another order. Here is Milot as per state letter so the petitioner already deported or already been deported so the Bangladesh on so the Mankarsar petition. Yes. Oh, I need to know. No. Okay.
Previous order may also be to. Five to 2010 order was also there.
Yes, that
Eh,
this is also the different one.
Previous order to lyrics. In terms of order passing
Hmm.
5 to 2010.
Not issue billet.
Uh-huh.
Yes, billet. Yes. Take a Sharma. Bill judgment nine.
5 to 2010 order was not reflecting here, Lordship. And Lordship, as per 19/5/2010 order, Lordship, that report was submitted on 14/6/2010. And 19/5/2010 order,
No,
5 to 2010.
this is
Lordship,
something
there
else. This would be something else.
Yes.
Yes,
This
Lordship.
is something. It's
190 is not the case. No, leave it. This is not the case.
wrong pending.
Hmm?
Wrong pending.
Pending DNO, 5 to 2010 order.
तो पहले की issue table negative. issue table ऐसे कुछ परिमाण है ऐसे परिमाण है ऐसे प्रतिक्रिया हेतु पता पे हेतु WhatsApp पर एक क्या बात है
5 to 2010 order to come.
आते कुछ के
It is the finding of the tribunal to the effect that filing of some documents and picking up a name from such document so as to establish relationship with the said person as father or mother or even grandfather or grandmother does not establish Indian citizenship of a foreigner. Further holding that discrepancy in the name of the opposite party and his father with the name in the documents filed by him cannot be taken as a legal evidence to confer Indian citizenship. Full stop. It may be mentioned that though the learned tribunal has referred to the has referred to WPC 190 of the 2009 dash state versus Mohammed MD Abdul 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 Qudus. But is same is not available in any reported judgment. Public order. Full stop. Next paragraph. Thus, comma, is court is inclined to hold that the non-discussion, the alleged non-discussion of the evidence of DW2 and DW3 in the manner projected by the learned counsel for the petitioner is not found to have prejudiced the petitioners in any way. Because all the documentary evidence has been dealt with by the learned tribunal. Next paragraph. My father came prior to 1965. In the same sentence, comma, the petitioner, within bracket DW1, has also stated that his father was also born in Assam. Therefore, there are two inconsistent statements by the petitioner regarding the existence of the projected father of the petitioner in Assam. Resultantly, comma, the reference as answered by the learned foreigners tribunal wide opinion dated 27/8/2013, page 80, as concerns principle, and type copies at page 73. Does not warrant any interference insofar as the petitioner number 1, comma, namely, comma, Muhammad Ahmed Ali is concerned. Next part is resulted, comma, this petition stands dismissed. Next part, there is no others to cost. They was dismissed. So the consequences of the said opinion will shall follow in respect of petitioner number 1, and not on the petitioner numbers 2 to 6, against whom the opinion has been set aside. There's been no orders to cost, and then that the records of the tribunal be returned back along with a copy of the order to be made a part of the court. Next para, the petitioner numbers 2 to 6 is directed to produce a certified copy of the order before the Superintendent of Police, Border Morigaon, to bring the order to the notice of the said authorities. Next para, the setting aside of the opinion against the petitioner numbers 2 to 5 shall not preclude the Superintendent of Police, Border Morigaon, to investigate, to carry out the investigation, if any, against those petitioners, and to submit reference against them, if any materials adverse to them are found. Two to 6.
Upgraded item 15 for hearing.
How much time will take? Lordships. How much time you are proceeding to take?
Lordships, will take a little bit time. Lordships, this matter came up on 4/6/2025, Lordships.
No, it may come up for hundreds of times. That's not the issue. Today we have 10 minutes time. Can you complete it within that time?
It will take a minute.
Because bench is only for that. We are not keeping it parted because we are not aware of our next roster. Suggest a date, both of you,
9th September,
9th September.
Lordships.
Okay. Okay, due to positive time, both sides are represented. Due to positive time, the hearing could not be taken up. Next is suggested by the learned counsel for the petitioner and the learned senior counsel for the respondent. List on 9/9/2025. You are hearing? Okay. Mr. H.K. Hazarika, the government advocate, is present. You and submits that the original record is available with him. So let the said record be retained by him till the next date of listening. Yes.
The Lordship is rising there.
No, because Mr. Sharma is also standing up. Anything? No. Okay. You're together with Mr. Sharma? Okay. Yep. Rise early.